The courtroom ran cold on a summer afternoon, the kind of institutional chill that made paper curl at the edges and gave breath a faint tin smell. Fluorescence hummed above paneled wood and government seal. The court reporter's hands hovered like a pianist, deciding where to land. People crowded the benches with the wary restraint of commuters, pretending their eyes weren't fixed on the young woman in jail orange beneath an ill-fitting county denim jacket. She walked with a careful economy that said she had learned to be smaller than problems. Her name was Amara. She was 19, with the soft jawline of a kid and the unslept eyes of someone who'd run out of soft places. On the prosecutor's screen, trial photos blinked one by one as if they could be made new by repetition. A corner store parking lot at 1:24 a.m., the sodium lamps painting halos in the mist from a refrigeration unit. A clerk, Rafael Oliva, 47, kind eyes even in the still shot, behind a counter stacked with scratchers and gum. A hooded figure ghosting through the door. A muzzle flash that turned a frame to lightning. The blurred collapse of a body that, in the courtroom stillness, sounded like it should have made noise. The state's story had been easy to hold if you didn't squint. A partial print on a candy bar wrapper, a phone tower ping near the market, an eyewitness outside who had bummed a cigarette and a ride and changed his name twice before settling on one, that matched a birth certificate someone eventually found. On cross, the defense had pried open tiny doubts. The video timestamps weren't synchronized perfectly. The residue swab on a hoodie might have been contaminated when an officer cut it off her near a dusty range where her ex shot beer cans. The eyewitness had started his night drunk and ended it bad at telling time. Common sense is synchronized, the prosecutor had told the jury on redirect, as if reason itself could be an expert witness. 12 heads nodded in a small, exhausted rhythm. They had offered her 25 to life if she would say she did it and promised to be sorry forever. She had said no. She had been on a city bus coming home from the late shift at a call center where people measured minutes in dollars and supervisors in clipboards. The bus company couldn't find the GPS logs for that night. Either the archive had been purged, or the request had been misrouted, or the system didn't keep data that long unless someone paid to keep it. 3 explanations rotated through 3 agencies, depending on the day you asked. The driver remembered bad brakes, not faces. Her mother had sat in the second row every day of trial and sat there now, hands flat on a purse as if bracing herself against wind. Lines around her mouth leaned toward prayer out of muscle memory. She wore her Sunday cardigan, though it was Tuesday, and the air conditioning did most of the work. When the prosecutor said, "the defendant," her eyes flinched at the word like it was aimed. The judge had a face that did well in newspapers. Silver hair, the bland gravitas of a person who golfed in silence. He had kept the case tidy, motions denied in the same tone as motions granted, rulings poured from neat pictures. Now, with sentencing on the calendar, he shuffled statutory forms, as if making sure the arithmetic of the law still added up to a number he recognized. Victim impact, the prosecutor said, voice low, managerial. A sister spoke first. A life resumed without its anchor. A calendar of birthdays that would be observed, not celebrated. The clerk's teenage son read a letter in a careful monotone that broke twice and recovered twice. He described eggs cooked the long way on Sundays, a minivan that smelled like pine trees, and a habit his father had of saving receipts just in case. A line that made 3 people in the gallery wipe their faces for different reasons. No one needed to instruct the room to be solemn. It had been solemn for months. The prosecutor asked for life without the possibility of parole and said the words deterrence and community safety the way a meteorologist names fronts moving in, as if he had no authority over the weather he described. The defense asked for a chance at parole even decades from now, his voice finding the register public defenders learned to keep for rooms like this, sturdy and unblaming. He said his client maintained her innocence. He said there were questions an adequately funded defense could have chased that he couldn't. He didn't apologize for that. He didn't have a mouth big enough. The judge turned to Amara and asked if she wished to be heard. The question came out gently, but had the edges of a ritual. She had rehearsed answers in the transport van, the cuffs licking at her wrists each time the driver braked too hard, the metal bench vibrating her bones into a kind of numb. She had pictured a documentary voiceover, imagined herself from above like a map someone else would read. In the chair, under the state seal, her voice came out steadier than any rehearsal. "I didn't do this," she said. "I was on a bus. I asked for the logs. They're gone." She glanced at her attorney's sleeve and decided not to say the next part into the record, that she had asked for a different lawyer and gotten a different answer. The judge inclined his head, and the court reporter, who had recorded countless denials and recantations and begged mercies, kept typing as though these were the words required to set the gears in motion. The statutory language landed in the room like weather, counts, enhancements, code sections that cut time into blocks and stacked them. The judge didn't raise or lower his voice when he said life without the possibility of parole. He didn't need to. It remained in the air with its own gravity, and everyone adjusted around it. Amara felt it as a measurement, not a verdict, a way of pinning a life to a grid. She breathed in once like someone surfacing, and then said the sentence she had sworn to herself she would say only if the room left her nothing else. "I want my father," she said, the words pushing up like a pulse. "I want my father, the Attorney General." If silence fell, it was the particular silence that is really noise redistributed, shoes scraping, a cough misfiring, the soft electric buzz of phones, learning the world had changed. The prosecutor's eyebrows climbed 2 clicks. The defense attorney's mouth opened in a perfect small O before closing around an apology he didn't know how to form. A deputy took half a step closer to Amara on instinct because the body remembers where to be when a room tips. "Counsel," the judge said, eyebrow arrested at mid-arc, "what is your client doing?" The defense attorney stood into the question. "Your Honor, this is not information I possessed before this moment," he said. "I'm learning it alongside the court." He looked at Amara with a knotted expression that contained 3 questions and 1 complaint. She held his gaze a heartbeat and then returned to the bench, because there are moments when the only thing you can do with another person's disappointment is let it pass through you like a draft. "Ma'am," the judge said to Amara, trading robes for bedside manner, "you just made a statement with potential implications for these proceedings. Are you representing to the court that the Attorney General of this state is your father?" "Yes," she said. No one in the room could hear the part of that word that was private. The years folded into it. The letters of his name she had avoided writing. The idea of a door that was never entirely closed because the hinge was cheap. Her mother made a small sound and pressed a hand flat to her chest as if to hold her breathing in place. In the back row, someone whispered, "No way," and someone else said, "Who?" as though missing the plot and catching up mid-episode. The prosecutor's tablet brightened in his palm. Tendons in his neck rose as he typed. Somewhere in a building with better carpet, an executive assistant's phone began to shriek on silent. "We'll take a brief recess," the judge said, tone restored to the professional weather. "Counsel in chambers." He glanced at the deputy. "Secure the defendant. We'll reconvene in 15 minutes. They walked her through a door that closed with bureaucratic finality and sat her on a bolted bench in a holding room, painted in a color that used to be beige. A vent rattled. On the other side of the cinder block, the courthouse bloomed with muffled activity. Call chains firing, emails splitting into threads, a clerk asking a staff attorney if there was a precedent for this and getting a head shake that meant there were precedents for everything and for nothing. She thought about a man she had known before he was in office. The first version of him had smelled like axle grease and oranges. He had lined up his shoes by the door like a habit of order, forced into a life that didn't have room for much of it. He had carried her once on his shoulders when she was 5, and for a day she had believed the world was built to be seen from that high. Then he had been gone. Child support sometimes arrived in an envelope, sometimes in weekends with borrowed cars and promises that sounded like small fireworks in daylight. When she was 13, she had Googled his name and found a clip of him at a podium with a lower third graphic identifying him as an assistant attorney general. The clip had looked like a movie filmed in a language she might be able to learn with practice. When she turned 18, the caption began using the definite article, the Attorney General, and she had watched the oath on a cracked screen in an apartment that smelled of soap and onion, thinking, okay. She had decided not to tell her public defender because she didn't want to be saved by a fact that felt dirty in her mouth. She hadn't told friends because secrets plus envy equals stories you don't survive. She hadn't told her pastor or the neighbor who baked pies for undeserving causes and would have made this one too righteous to hold. She hadn't told her mother on purpose, though her mother had guessed and closed her eyes and rubbed the bridge of her nose and said, "Then we do not use that. We do not." In chambers, the judge sat at a round table with a nick in it shaped like an unspoken word. The prosecutor looked as if a manual had been taken away just when he needed the diagram. The defense attorney had sweat blooming on his collar like a map of a small island. The court staff attorney had a laptop open to judicial ethics canons as if the words appearance of impropriety could be an anchor instead of a balloon. "We have to address the integrity of the proceeding," the judge said, counting. "Conflict concerns, potential recusal issues, and whether sentencing should be stayed pending motions. I'm not interested in theatrics. I am interested in not breaking anything that cannot be fixed." The prosecutor spoke first. His office was county, not state. The attorney general had no supervisory authority over his decisions. The jury's verdict was based on evidence. The sentence would be based on law. He would, however, be contacting the AG's office for confirmation and for the inevitable communications implications. He said the last words like he regretted having a mouth. The defense said that if the claim was true, the risk of public confidence eroding was not theoretical. He gestured at nothing with both hands as if trying to hold a concept. He said the words conviction integrity unit and newly discovered evidence and stay of judgment and conflict-free counsel in a row like beads threaded to look like a necklace. He did not say the quiet part about leverage. He didn't have to. The staff attorney pointed the judge to rules that could support a temporary pause. She drafted a sentence and slid it across the table. "The court will stay entry of judgment for 48 hours to allow counsel to file any appropriate motions and will set a status on conflict issues." The judge read it, nodded, and said, "That's the road." They returned to the bench. The gallery had repopulated with new faces, reporters trying to be invisible, attorneys from other floors pretending they had business here. The judge announced the stay in his clipped, careful cadence. The prosecutor did not object. The defense agreed, like a man who had just been offered a life raft with a limited weight capacity and no oars. The clerk marked a new date on a calendar and tried not to think about the shift she would have to trade to make it. When the deputy walked Amara back out, the hallway had the suddenly collaborative energy of a disaster drill. People moving briskly without eye contact, phones held low like contraband candles. Outside, under the courthouse steps, a reporter with a sprayed-into-place bob practiced into a camera. A shocking turn at sentencing today. And a videographer adjusted focus as if clarity could be willed. The jail processed her return with the manners of routine. A corrections officer she knew from intakes slid a clipboard across a counter and tried a smile that didn't disrespect the day. They moved her to a different unit because profile, the officer said, with a half shrug that apologized for a word used to mean something else in another context. The new cell had a single bunk poured out of concrete, a thin mattress that picked a fight with every bone in her back, and a slit of a window that offered sky like a ration. A legal call came through that evening. The voice belonged to an attorney from the Attorney General's office and sounded like sentences had been ironed before they were spoken. She said the Attorney General would recuse himself from any involvement in matters related to the case announced in court, and a special counsel would be appointed to oversee any interactions between state and county agencies. The Conviction Integrity Unit would accept any formal petition and process it according to published protocol. She used the word alleged before familial relationship and the words no further comment after everything else. When the line clicked off, the quiet returned in a single damp exhale. Amara's appointed attorney came the next morning, yellow legal pad fluttering with sticky notes and neon triage. He asked why she hadn't told him. She asked if he would have used it to cut a deal he'd call a win and she'd call a wound. He said he wouldn't have. He looked embarrassed by the easy lie and shifted to the work. They would file a motion for new trial. They would file to compel the bus company to cough up any breadcrumbs of tracking data. They would ask the court to let them hire a technical expert to audit the store cameras and the chain of custody on the hoodie. They would ask for conflict-free counsel to advise on the tangle she had just pulled into the room by saying a true sentence out loud. He warned her about the word she'd never invited but now lived with, optics. Attention could keep a person safer in a jail sometimes and could draw the kind of heat a unit wasn't designed to disperse. He told her how to keep her head down while standing in the middle of a city square. She listened without looking away, absorbing logistics the way you memorize the path to a job you hate. By noon, the AG's office posted a statement full of neutrals, recusal, special counsel, protocols, professional distance, and reporters filled the gaps with speculation phrased as questions. Talk radio listeners learned to pronounce conflict of interest in a hurry. In the evening pod, the TV in the day room ran a segment with a blurred photo from a high school yearbook that might have been her, or someone shaped like her. The other women tilted their heads toward the sound. A tall woman with a bluebird tattoo asked, "That really your daddy?" And Amara stared at the stainless steel sink until her own face in it became a distortion that didn't belong to anyone. In the city bus depot across town, a supervisor printed 2 contradictory memos about data retention so he would have whichever one survived the day. An IT contractor for the corner store chain scrolled through a service history and found tickets about time drift on DVR units that nobody had escalated because nobody cared until somebody had to. A junior assistant in the prosecutor's office learned to spell metadata and exculpatory in the same hour. On a different floor of a different building, the Attorney General stood by a window and watched the government campus glow like a diorama and told his chief deputy to keep his name out of anything that could glow back. He took off his tie and set it on a chair and called a number he hadn't called in years. He didn't leave a message. 48 hours stretched and then snapped. In court, the judge sounded exactly as he had before, as though affected neutrality were a virtue. He extended the stay of judgment until a hearing 2 weeks out on the defense's motion. He granted a limited order compelling the bus authority to produce whatever logs existed of a line that ran from the call center district to the neighborhood where Amara had lived, subject to redactions that would keep strangers' lives from leaking into hers. He denied funding for a second round of testing on the hoodie, but allowed the defense to retain a technical consultant to review camera systems within reasonable cost constraints. The prosecutor objected to nothing in ways that would read reasonable in a transcript and safe in a headline. Back in her cell that night, a chaplain with the bulk of an offensive lineman and the gentleness of a children's librarian asked if she wanted to send a letter. He didn't say to whom. She took a pencil with no eraser and stared at legal pad lines until they blurred to soft rails. "I am going to say something to you that I should have said when I was a girl," she wrote first, "because you cannot step onto a rope bridge without deciding to step onto it." She kept the rest practical because rage was a poor courier. "I told the court. I said your title out loud. They are going to ask you questions. I don't want your rescue. I want the truth to stand up by itself and stay standing." She signed only her first name, which was both obvious and not. Days thinned and thickened in turns, jail measuring them in mail calls and medication rounds. Her attorney returned with stapled packets smelling like toner and panic. The bus authority, grumpy and bureaucratically offended on principle, coughed up a partial export from a server that had not been backed up right, along with a disclaimer that would make a good umbrella if you believed in umbrellas. It was something like proof of a bus at a time that mattered. Whether it could be tied to her was a separate cliff. The corner store's security vendor sent a man with clean shoes and a nervous smile to the prosecutor's office. He mentioned, off the record that tended to be the only record, that their DVRS had a known clock drift problem after power interruptions and late-night updates. The prosecutor wrote it down and wondered how many jurors would care about clock drift if a widow's letter still smelled like pine and eggs. He sent a terse email to the defense about access to raw video, and then another to his own IT consultant to ask what raw meant. Amara's mother learned to let her phone die at night and revived it with morning coffee as if she were waking a relative. She dodged microphones by stepping sideways and opening her front door half an inch, pretending she couldn't hear the questions. A neighbor brought a casserole that couldn't survive the fluorescent light of the kitchen but tried. The pastor left a card with a phone number. The numbers on the card looked like a scripture reference and felt like instructions for grief. In a quiet hour between counts, a deputy stopped by the door of Amara's cell and told her the mailroom had logged a manila envelope inbound from the state office building with no return name on it. He didn't say he'd wondered whether it would come. He didn't say what he would have thought of the AG if it hadn't. He moved on to the next door with his keys and his policies. When she slept, the store's camera replayed behind her eyes the way a dream insists on being the last word. She tried to overlay the bus route on top of it, the fluorescent hum in place of the freezer's mist, a driver's board tapping replacing gunfire. Sometimes the two films refused to realign. Sometimes, for 3 long seconds before morning, they did. Her lawyer brought a printout 3 days before the hearing with 2 columns that wanted to be twins, but weren't. The store's inside camera running at one pace, the outside camera frame stamps running slightly ahead, as if a second hand had been caffeinated. "If the drift is real," he said, tapping a pen against the margin, "nothing in the video can be taken as a single clock. The jury saw one story. There may have been another." She nodded like an engineer, not a defendant. He took that as a good sign and didn't read too much into it. The next calling of the calendar looked like nothing special to the untrained eye. The bailiff intoned the same script he had said for 27 years. The judge wore the same robe he had worn when a toddler spilled a juice box on a public defender in the first row, and no one laughed out loud. But new energy had soaked the grain of the room. A young tech in a cheap tie sat behind the state's counsel table, palms shiny against a manila folder. A civil rights lawyer with a bow tie like a thesis slide took a seat behind the defense and nodded as if checking a box in a study. 2 rows back, a woman with a notebook and a press credential watched with equal parts hunger and restraint. Amara came in through the side door, flanked by deputies who had learned her pace. She looked past the benches to the clock above the door, felt its steady second-hand move, and thought, "If you were wrong, I will still keep moving. If you were right, I will not drown in the relief." And her mother caught her eye and mouthed a sentence that might have been one word, "Here." The judge called the case and asked for appearances. The prosecutor announced himself and introduced the state's technical consultant with a flatness that told the room he didn't trust this witness yet, but had decided not to be seen resisting math. The defense announced his own consultant, a woman with hair pulled back in a way that said she didn't intend to waste time. Nobody spoke the title Attorney General out loud. The air still held it like a secret shared too widely to be secret anymore. Somewhere between the clerk and the court reporter and the AV cart, the building exhaled. The courtroom doors settled on their hinges. The security officer by the scanner crossed his arms. The second hand leaped forward again. The day would unfold into vocabulary, offset, drift, latency, chain of custody, that promised keys where there might only be mirrors. The country outside would orbit the question of what fairness looks like when cameras make truths look harder than they are. The hearing would decide the next fight, not the last one. But that was later, minutes away, and also weeks. For now, the judge adjusted his glasses, and the first witness stood, and a story that had been forced into a single hard sentence began to loosen into parts that could finally be examined without breaking in the hands that held them. The tech on the stand looked too young to testify about time. He adjusted the microphone and said the words, "clock drift," with the care of someone placing a hot pan on a table. His hands framed invisible boxes to show how a store's inside camera and outside dome camera wrote their own versions of the same night, each using a cheap quartz heart that lost a few seconds here and there until the story slipped out of sync. He explained power interruptions and firmware updates at 2 a.m., the way DVRs applied an overlay after recording, not during, so the numbers at the bottom of the frame were more like captions than truth. He said offset, latency, and post-write stamp, and half the room wanted to lean in and half wanted to walk out. The prosecutor rose for cross and tried to make math sound like excuse. "Even if there's drift," he asked, "you're not saying the video didn't capture a shooting, are you?" "No," the tech said. "I'm saying you can't tell exactly when in wall clock time each frame happened unless you reconcile the devices with an external reference. Without that, the inside cam might believe it's 1:24:30 when the outside cam thinks it's 1:22:54. If you're matching an alibi to seconds or minutes, those minutes matter." The judge stared at the flat screens the court AV cart had rolled in, at the same 20 seconds of footage he'd watched 3 times during trial. The clerk marked the exhibit with a new letter. The defense asked permission for its own consultant to highlight a frame where a figure outside the store crossed a patch of light at a moment that, depending on which clock you believed, might have been before Amara's bus even left Midtown. "Objection, speculation," the prosecutor said, rising again. "Noted," the judge said. He didn't sustain it. He let the picture do what pictures do. When the clip ended, the air felt like someone had opened a window in winter. By the time testimony paused, the judge had granted a narrow order. The store's vendor was to produce raw video without overlays. The transit authority was to turn over any logs still living in any server or backup. He extended the stay on entering judgment and set another hearing in 2 weeks. He denied, without prejudice, funding for a second round of residue testing on the hoodie. He said the phrase materiality twice as if to remind both sides he remembered what the law required when it decided whether doubt was the size of a keyhole or a door. No one spoke the title that hovered like static in the room. The Attorney General didn't sit in the front row. He didn't sit at all. If he watched, it was through a screen in a building with thicker carpet and coffee that never burned. After court, the hallway boiled. Reporters stood on tiptoe to catch reaction shots. The defense told microphones he was encouraged by the court's willingness to reopen the technical record. The prosecutor said he respected the court's careful approach. and remained confident in the jury's verdict. Two strangers argued near the security scanner about whether technicalities were how guilty people got to rebrand themselves as victims. Amara's mother slid past them with her head down, as if cutting through was the last privacy she could exercise. In the jail that night, the Pod TV cycled through a segment where a commentator used the phrase special treatment 3 times in 2 minutes and then pivoted to a panel about urban crime like it was a genre. A woman 3 bunks down spat the words at the screen. "If my daddy had a title, I'd ask for it." Someone else said, "Title can't swap a verdict." And everyone went quiet because hope is valuable and loud. The bus authority coughed up data the way a cat coughs a hairball, reluctantly, with drama. A systems engineer in a room with drop ceiling tiles wrote an affidavit about a legacy server that archived route pings every 15 seconds and kept the data for not less than 90 days, unless a litigation hold was applied. There had been no litigation hold. Still, a partial export survived on a mirrored drive, a line of GPS points that traced a slow rectangle through the city at a time that mattered. Whether Amara was the person on the bus wasn't in the numbers. Numbers don't swear to tell the truth. People do. The defense investigator drove to the end of the line with a pocket spiral notebook and a patience developed over years of bad coffee. He found the driver, a woman with the practiced stare of someone who'd learned not to let the city inside. She didn't remember faces on a particular night 3 months ago, but she remembered a girl who apologized every time she squeezed past other passengers because she was carrying a headset and an overcoat in June and looked like someone who had been told a long time ago to be careful with other people's air. "Blame the coat," the driver said, made her hot and polite. The store's vendor met the prosecutor's IT consultant in a conference room and handed over 3 portable drives labeled RAW_A, RAW_B, RAW_EXT. He signed a chain of custody form and then said, "Off the record, your DVRS are notorious for clock issues, and the 2 a.m. updates pushed them over." The consultant nodded gravely and made a note. Later, he emailed the defense the same thing, minus the off the record. The game is always to get the truth to sit where it can be sworn to. Inside, the jail did what jails do, reduce everything to rounds and rations. In the afternoon, the chaplain stopped by Amara's door and said a manila envelope had arrived with a state office return address and no name. She stared at it as if it might confess before it was opened. When she slit the flap with her nail, she found exactly 4 sentences in a careful hand she recognized from old forms and a childhood letter on a birthday that didn't land on a weekend. "I read the transcript. I have recused. I am taking steps to ensure independent review where the law allows it. I cannot and will not try to be your lawyer. No, I love you. No, I'm sorry." He had never been a man to put 2 sentiments in one envelope. At the bottom of the page, a single initial, taken from a name he'd given her and then taken from himself. She folded the paper along its creases and thought of physics, how touch becomes heat, and how heat, in a closed system, stays. The next status conference started on time but felt late. The defense's consultant had ingested the raw files. She clicked through frames like a surgeon showing a heartbeat bent by a miscalibrated monitor. She overlaid a clock from the store's point-of-sale system, accurate because it synced nightly with a bank server, against the DVR stamps. The offset wasn't constant. It wandered and then jerked forward. If the jury had believed 1:24:30 because the number sat there bright as a streetlight, science now suggested the event could have been closer to 1:21 when you let the point-of-sale clock lead. The bus logs had a ping at 1:18 on Elm and a ping at 1:23 at Mercer. If Amara was on the bus, she would have had to step off at 1:20, run 6 blocks, become a shooter, and be back on wheels before the driver closed the doors. It wasn't impossible. It was implausible enough to matter. The prosecutor dangled a new thing. "We have a letter we're obligated to disclose," he said solemnly, as if generosity were a policy initiative. A jailhouse informant, housed briefly in the same unit as Amara during pretrial, claimed she had confessed in a low, exhausted voice to being done with being poor the slow way. In return for his letter, the informant hoped for consideration on a pending parole violation. The judge's mouth made a flat line, the shape of a person stepping on a rake and refusing to grimace. Jailhouse letters are America's cheapest currency, always stamped with urgency and paid for by someone else's time. The defense filed a motion to strike the letter as unreliable and retaliatory. He attached statistics and a report from a wrongfully convicted man whose life had been turned by a confession recorded on toilet paper and corroborated by nothing but need. He asked, in a tone that borrowed steel from people who had burned out before him, whether the court intended to let new trash drown old doubt. The judge set the informant matter for a separate evidentiary hearing. He returned to the math. On the current record, he said, the court sees questions about timing that could bear on identity. The court also sees an eyewitness who testified at trial under oath and whose credibility attacks were put to the jury, a residue test the jury heard about, and a verdict that reflects the reconciliation of contradictions. The court needs more than static to vacate a verdict. The defense asked for a new trial. The prosecutor asked for the court to deny and proceed to sentencing. The judge took it under submission. The hallway filled with low thunder. Outside, the city leaned into the story. The talk radio man upgraded special treatment to elite bloodlines. A cable anchor said "black girl" into a camera with an inflection that turned the words into a commodity. In a coffee shop near the courthouse, a woman hissed to her friend, "Bet if she was mine, I'd name names sooner." At a barber shop across town, a man with a salt beard said, "If the truth were worth less, they'd have sold it already." This is Dasta, eyewitness, the one the defense had called Mr. 47 names, left a voicemail on the investigator's burner. "I gotta fix something." They met in a parking lot behind a payday loan office where cameras faced the front door and left the shadows alone. He was shaking. "They told me what they wanted me to see," he said. "They said, 'That hoodie, that's her, right?' What kind of question is that?" He signed an affidavit with a pen that didn't want to work. 2 nights later, he called again from a number that traced to a motel near the interstate, voice thick with fear. "Someone knocked. That ain't the front desk," he said. The line went dead. When the investigator went out there with a cheap motel coffee clenched in one hand, the room was empty except for a Gideon Bible and a wrapper from a chicken sandwich that had outlived its heat. The prosecutor filed a brief citing the unreliability of recantations procured post-verdict and attached a law review article that said exactly that in disciplined prose. The defense attached a picture of the motel door with fresh dents near the latch to a motion for protective order that the judge would later say he lacked authority to issue because the witness wasn't a party to the case and the court wasn't a police precinct. Amara went to sleep on the thin mattress and saw an old ride with her father, 17 minutes of quiet on the freeway where the sound of tires ironed the space between them flat. In the morning, a deputy slid open the door flap and told her to put on the jacket. She asked if it was for court. "No," he said. "Interview room." The special counsel the Attorney General had appointed, imported from a neighboring state to satisfy the gods of conflict, sat at the teleconference screen with a paralegal and a carton of unsugared yogurt. He explained, in words that had been scrubbed of adjectives, what a conviction integrity unit does and doesn't do. "We review process," he said. "We do not redo trials." He asked for her consent to obtain her phone records directly from the carrier, separate from discovery. He asked permission to subpoena footage from a city-owned camera at the intersection 2 blocks from the store, a camera the defense had been told didn't exist, then existed but was facing the wrong way, then existed but overwrote after 72 hours. Unless the city department placed a hold. The paralegal's eyes flicked up at that. Her notes were tiny and exact. "Why would the city place a hold?" Amara asked. "If the police asked them to," the special counsel said. He didn't shrug. He didn't need to. Her mother met her appointed lawyer at a diner because the church basement had started to feel like a set. They sat in a booth that had nursed 1,000 other crises and shared an order of fries. Squeezing ketchup like precision would help. "You're going to ask him to testify," her mother said flatly, not looking up from the plate. "You're going to put him on a stand and make him say something we can never take back." "If we subpoena the head of CIU," the lawyer said, "it won't be him. He's recused." "You know what I mean," she said. "You're going to ask the man to be a father in public." He tried not to sigh, because the sound would have been more about him than about need. "I'm going to ask people with the power to open doors to open them," he said, which was as close as he could get to truth without breaking something that still had a chance. When the judge finally ruled on the new trial motion, he did it from the bench, not in a written order that could be pored over for footnotes and subtext. He spoke carefully. The timing anomalies were troubling, the bus data suggestive, though not conclusive, the jailhouse letter unpersuasive without live testimony, the recanting witness unavailable and uncorroborated. He quoted a case about the heavy burden on defendants seeking to upend verdicts on newly discovered evidence. Then he denied the motion. The stay on entering judgment would expire in 7 days. He said he did not do this lightly. He said the path forward was appeal. In the second row, Amara's mother gripped the purse so hard a seam finally snapped. The defense sat back like a boxer learning to smile with a swollen lip. The prosecutor's shoulders sagged in a way that could be read as relief or fatigue or belief that gravity had briefly remembered itself. That night, the pod TV showed a split screen. On one side, the courthouse steps. On the other, a statehouse hearing room where the attorney general sat at a long table with a microphone and a nameplate. The chyron read, "Attorney General testifies on police identification practices." He spoke in the tone of a man delivering a budget report that also happened to be a confession. He outlined policy recommendations on eyewitness procedures, double-blind lineups, confidence statements recorded verbatim, cautionary instructions that the suspect may not be present. He spoke about the reliability of consumer-grade DVR clocks and the need for law enforcement to treat time overlays as approximations unless validated against an external source. He did not say her name. He did not say daughter. He said the word integrity 8 times. At the end, a committee member asked him whether his recommendations had been shaped by any particular case in the news. He said, "No, Senator. They were shaped by the duty of our office to get it right." The next day, a detective who'd worked the corner store murder for the first 48 hours before being pulled to a different case sent an email from his private account to the special counsel's office. The subject line read, "Something you should see." It attached a PDF export of a chain between a city surveillance tech and a police sergeant. Hold placed on municipal cam 1237 at first and Alvarado, it read, with a timestamp from 3 hours after the shooting. Copy pulled by request. The copy was never logged into Discovery. The defense had never seen it. The municipal IT office had declared in response to an earlier subpoena that no relevant footage remained. The email might have been nothing. It might have been a key. In the motel off the interstate, the eyewitness left an envelope with the clerk, addressed to the lawyer, then disappeared again. Inside was a napkin with 4 words. They showed me photos. Beneath it, a phone number with 2 digits reversed, as if fear had shaken the hand that wrote it. The investigator fixed the number by intuition and dialed. A burner chirped unanswered in a trash can behind the motel where the clerk took smoke breaks. The prosecutor filed notice that he would call the jailhouse informant at the sentencing hearing if the court allowed it, to speak to remorse where the defendant has claimed none. The defense filed a motion to exclude. The judge set argument for the morning the stay expired. A deputy passing the day room stopped to watch the news with the women, arms crossed. On the screen, an anchor toggled between words like controversy and reform, hands moving as if to keep the balance. A crawl at the bottom broke the rhythm. Leaked emails suggest police pulled city camera footage night of shooting. The deputy whistled under his breath the way men do when something large moves under the water. In the basement office of a precinct where ceiling tiles bowed, a sergeant stared at a printout of his own words on letterhead he hadn't written them on. He thought about the copy he had signed out from Municipal Cam 12-37 and who had asked him to put it on a thumb drive and who had told him not to log it because chain of custody is a vibe, not a rule. He thought about the attorney general saying integrity into a microphone without saying anyone's name. He thought about pensions. Then he shut off his monitor and went home, heart hammering like something trying to get out. At midnight, Amara lay on the mattress, letter from her father tucked under it like a relic. She found the tiny comfort of knowing which hour the jail went quiet and which hour woke up again, a living animal breathing on a schedule. Before she drifted off, she whispered a sentence into the seam where the wall met the bed, a place where she imagined wishes could wedge and hold. Don't let the truth depend on me needing you. In the morning, the door slot clanged open. Legal mail, the deputy said, sliding in a photocopy. The special counsel's office had formally requested any and all materials relating to Municipal Cam 12-37 from the city surveillance unit and any law enforcement entity. A second page noted receipt of a partial export pending verification. The sentencing calendar remained posted. The judge's name remained next to a time. The country's machinery clicked into its next notch. Somewhere in a different building, the Attorney General closed his office door, picked up a pen, and signed something that would either be read as a routine administrative step or as a man lighting a fuse under his own desk. Outside, the city blinked into heat. At the courthouse, 2 television trucks idled as if they had never been turned off. In a suite of rooms where executives planned angles and phrases, someone said, "We should lead with the leak," and someone else said, "We need a face to go with it." In a row house where a mother had turned her living room into a waiting room, the phone rang again and again. Sometimes she answered, sometimes she let it ring until both the caller and the sound gave up. The bus route that had been a line of points on a server still ran, stopping at lights where the same driver tapped the wheel with the same tired precision. Passengers got on, passengers got off. Time drifted a little, then snapped back. In the courtroom, a new day would begin with argument over whether a man hungry for a parole date could be the voice that spoke to Amara's soul, and whether a missing witness's napkin could weigh more than a scripted letter. The judge would measure materiality again like a jeweler weighing stones. And somewhere between the testimony about clocks and the emails about cameras, a human decision would have to be made about what counts as enough to pull a life back from the grid it had been pinned to. The door to the courtroom opened and the first bodies slipped in, quiet, as if quiet could coax mercy. The bailiff lined up water cups with the same neatness he'd used for 27 years. The court reporter set a fresh stack of paper because Story eats paper when it's hungry. And in the back row, a man in a plain suit stood with his hand on the door jamb, not taking a seat because sitting felt like claiming a place he wasn't sure he was allowed to claim. He stared at the bench, then at the counsel tables, then at the empty chair where his daughter would sit when they brought her in. He didn't move when the bailiff said, "All rise." He rose with everyone else, late by half a beat, learning the choreography of other people's rituals again. The judge came in. The clock over the door ticked audibly for the first time in weeks. Somewhere, a camera saved or didn't save what it had seen. Somewhere, a thumb drive waited in a drawer under a box of rubber bands, and a man whose conscience had begun to itch reached for it with a shaking hand. Time, dishonest and essential, kept. The courtroom filled like a lung and held the breath. Sentencing calendars moved other bodies in and out, but this case had a gravity that bent traffic. The prosecutor set out his stack of exhibits with the sacred care of a man arranging tools, then slid a new folder to the top, the letter from the jailhouse informant, so the tab peaked like bait. The defense checked his yellow pad, looked once over his shoulder at the gallery, and caught the posture of a man in a plain suit standing in the back, not claiming a seat. No one said the title out loud. It hung in the air the way a smell does, present even when not spoken about. The first argument was about whether a man hungry for a parole date could be the voice the court should trust to speak to anyone's soul. The prosecutor called it context for remorse, a phrase polished until you could see your own face in it. The defense called it garbage by another name and cited studies and cases that dragged informant letters into the light and measured how quickly they shriveled there. The judge let the lawyers circle, then said he would hear the informant live before deciding whether to admit him as proof of anything beyond his own need. They brought the man in from county and clothes the color of concrete. He had the beaten air of someone who had learned to lower himself before others lowered him. He swore, he sat, he cleared his throat, and he said he had heard Amara in the day room say she was done with being poor the slow way. He added phrases the prosecutor could recite in closing like scripture. On cross, the defense asked him how many times he'd written a letter like this, how often it had been traded for a date that moved closer. "You ever misheard something and sold it as truth because truth and price look alike in the dark?" the defense asked. The man blinked, then said he didn't know how to answer questions that were really sermons. The judge thanked him and said he'd take the matter under advisement. The room exhaled without meaning to. The special counsel's motion was next, filed under the seal of independence. Admit the municipal camera footage obtained by subpoena from the city's surveillance unit, together with declarations establishing its chain of custody and the circumstances of its retrieval. The city tech had initialed the export. The police sergeant had signed an affidavit acknowledging he had requested a copy the night of the homicide and had not ensured it was logged into Discovery. The affidavit had been written with the spare grammar of a man carving words out of his own throat. "Why now?" the judge asked, eyes on the sergeant's name. "Because he has counsel," the special counsel said. "Because the leak forced an accounting. Because he would like to stop dreaming about it." The prosecutor stood, jaw tight. Your Honor, we object on chain of custody grounds and on the prejudice of introducing material the defense did not pursue pretrial. The defense did pursue it, the special counsel said, even-toned. They were told it didn't exist, then that it did exist, but faced the wrong way, then that it overwrote in 72 hours. The evidence log reflects no hold placed by law enforcement. This, he tapped the email thread attached to his motion, reflects a hold placed at 4:18 a.m. and a copy pulled at 6:02. If the state wishes to litigate the reasons for the discrepancy, we can do that. I would like, however, for the court to watch the video. The judge nodded once, and the AV cart was rolled forward like a sacrament. The municipal feed bled onto the screen, wide angle, black and white, the corner where first crossed Alvarado. At 1:20-something, a sedan rolled through the frame, the sort of nondescript car that lets a city breathe its own monotony. At 1:22-something, a man in a hooded jacket moved across the far edge of the frame and ducked into the corner store door. At 1:24 or 1:21, depending on which clock you believed, the same man stumbled out with a hitch in his gait, a limp like a bad hinge. He got into the sedan and it pulled away west. The plate caught the light for a fraction, a partial 7V-something-3. The defense consultant overlaid a timestamp from the store's point-of-sale system onto the video in the corner like a second hand, then toggled back to the bus pings. On a split screen, a bus idled at Mercer. The judge leaned in. The prosecutor pinched the bridge of his nose and did not look up. "We'll need more than this," the judge said when the clip ended, voice flat to keep from cracking. "But more is now possible." The prosecutor asked for a recess. He walked into the hall and called his bureau chief and said a sentence that could be understood 6 different ways. "We have a Brady situation." He listened to the silence on the line, then nodded at something no one could see. When he returned, his manner had shifted by a degree small enough to deny, less combative, more careful. The sergeant took the stand, hands open the way a man shows he has no weapon. He said a supervisor told him to get the municipal copy as insurance. He said no one told him to log it. He said he should have done it without being told. He did not say the words confidential informant, but he did say there was another person of interest who had some history with narcotics, and the courtroom filled in the rest with a collective shiver. He looked at the floor when he spoke the last part. We were told the case needed to be closed. In a separate hearing in chambers that afternoon, the judge listened to counsel speak obliquely about protection agreements and operations that do not, like daylight. It was the sort of conversation that makes walls itch. The special counsel said finally, if an informant was present at the scene, and that fact was known to law enforcement and not disclosed to the defense, the state's case is open to collapse. If footage exists that could identify another participant or provide exculpatory timing, and it was withheld, we have more than mere negligence. The judge rubbed the flat between his eyes with 2 fingers, then set another hearing for the following morning. He ordered the city to produce a clean export of the municipal footage and any logs that tracked who accessed it and when. He ordered the department to produce all reports referencing a second suspect, redacted as to operative names, but sufficient to allow the defense to test identity. He asked for supplemental briefing on remedies. That night, news crews camped under a sky that thickened with heat. The commentariat chewed through phrases, procedural failures, exculpatory evidence, win at all costs, and spat them back out. A State House beat reporter posted a copy of the subpoena return from the city surveillance unit. Municipal Cam 1237, hold placed, copy pulled. A police union account suggested the sergeant had been misled by new leadership's political maneuvers, and a reply thread bloomed into a fight that would last until morning. In the jail, the pod TV went on mute, and the subtitles crawled, thin and insufficient. Amara lay on her bunk and tried not to translate terms of art into personal nouns. Morning brought the kind of light that reveals dust you didn't know you owned. The city's logs documented access to the footage by badge numbers the special counsel could tie to the sergeant and to a detective whose name had not appeared on any of the filed reports. The detective had transferred to a task force 2 weeks after the shooting. An internal email was attached as an exhibit, time-stamped 2 days post-homicide. Municipal capture shows our CHS's vehicle parked 1 block west. Will brief off-channel CHS, confidential human source. The defense underlined the sentence and wrote in the margin what everyone else was thinking. They protected their own. When court opened, the judge's voice had lost its casual pitch. He began by announcing that the informant's testimony would not be admitted for sentencing. Whatever he thought he heard, it was too unreliable to be the basis for any finding that mattered. The prosecutor didn't protest. His energies had been captured by the larger fire. The special counsel moved to reopen the new trial motion based on the municipal footage and the logs. The prosecutor began to speak, stopped, and then said the office did not object to reopening. He asked for time to review what his side should have had weeks ago. The judge gave him the morning and set testimony for the afternoon. In the hallway, the plain-suited man from the back row fixed his tie in a reflection he pretended not to see and told himself that this was what recusal meant, standing in a place built for the public and being only the public. He felt the weight of a tiny manila envelope he had carried and not delivered. Amara's letter, creased and recreased. He returned to the courtroom and stood again, a witness to a thing he had chosen not to control. The afternoon supplied the witness everyone had been waiting for and dreading. The municipal surveillance tech whose emails had been leaked. He swore and explained the system in clean lines. How holds were placed, how copies were logged. He had placed a hold at 4:18 a.m. A sergeant had retrieved a copy at 6:02. The tech didn't know what happened to the copy after it left his office. He looked like a man being asked to explain where the river went after it left his property line. The defense consultant then demonstrated the municipal footage stitched to the store feed and to the bus pings with the point-of-sale clock set as a metronome. The prosecution's consultant, perhaps smelling the shift in wind, agreed that the store DVRS overlays could not be trusted as absolute time, only as relative sequence. The judge asked the question that matters when a person's life is held against a grid. How confident are you that the event we saw on the municipal camera occurred at a time consistent with the bus's location far from the store? Confident enough? The defense consultant said that no reasonable juror could take timing out of the reasonable doubt column. The judge looked down at his notes for a long beat, the way people do when they are about to change the shape of a day. Then he said he would take a recess and return with a ruling. Waiting felt like work. The gallery buzzed low, like wires under a floor. Amara sat with her hands flat on her knees and kept her eyes on a point halfway down the prosecutor's table where a knot in the wood looked like a small galaxy. When the judge re-entered, the room rose and sat with the synchronized choreography of a small nation. He began quietly, which is how people tell the truth when they don't want to perform it. The court's role at this stage is not to retry the case, he said. It is to decide whether newly presented evidence, viewed in light of the existing record, would probably have changed the verdict. He recited the competing tests, the caution courts use so they don't become newsrooms, the humility they enact so they don't become legislatures. He said the withheld municipal footage, the city logs, and the absence of disclosure about a second suspect were deeply disturbing. He said the miscalibration of the store clocks, dismissed at trial as mere quibble, now carried weight when placed against a verified external reference. The state's case was not weak, he said, but it was not invincible, and the process appears to have been bent. He granted the motion for a new trial. The room did not gasp. It released air. He vacated the conviction and set bail review for the next morning. He set an evidentiary hearing on the source of the municipal footage's suppression and ordered the police department to produce a witness to address policy on surveillance holds and discovery. He did not say the word sanction. He did not need to, yet. The prosecutor stood. He asked for a moment to confer with his superiors. He walked to a corner with his phone and stood in that strange posture men take when they are listening to an authority they can't see and trying to keep their faces from broadcasting what's being said. He returned, leaned on the lectern with both hands, and spoke into the microphone in a voice that was suddenly older. "Your Honor," he said, "in light of the court's ruling and the evidence presented, the people moved to dismiss the case in the interest of justice." He swallowed. "With prejudice." The words landed with a geometry that rearranged the furniture. "With prejudice." The judge's eyebrows lifted the small distance they had available. He asked whether the motion came with the approval of the elected district attorney. The prosecutor said it did. The judge looked to the special counsel, who nodded once without smiling. The defense put his hand on the table as if to steady it. Amara's mother covered her mouth with both hands and then dropped them because she wanted to see the words. The judge granted the motion. He ordered the clerk to vacate the conviction and dismiss the charges. He set the evidentiary hearing on discovery practices for a date 2 weeks out because process still needed its accounting even after Mercy had moved. He looked at Amara as he spoke the last sentence. "Miss, L, you are released. The word didn't feel like fireworks. It felt like a bolt pried free that had held a door closed so long the door had forgotten it could move. The deputies did not touch her. They did not need to. Paperwork rustled into being as if it had been waiting in drifts. The reporter with the sprayed-into-place bob stared at her producer as if to ask whether tears counted as audio. Outside, the heat had become a wall. The steps filled fast. Cameras formed a chevron. Microphones bristled. The defense gave a brief statement with the practiced gratitude of a man who knows anger will be asked of him later, but not now. The prosecutor read prepared remarks acknowledging grave failures in discovery and processes that need urgent repair. He did not say anyone's name. He did not say the words informant or protection. He did say independent audit, and a dozen ears in the crowd marked the phrase and put it in next day's leadees. Amara stood with her mother on the sidewalk where the shade cut a tight trapezoid out of the day. She didn't speak. She let the air touch her bare forearms. The plain-suited man remained at the base of the steps with his hands at his sides. 2 cameras caught the moment he looked at her. One still image would land on the front page the next morning, cropped so that the space between them looked like a decision. They met 2 days later on a bench in a riverside park where joggers had learned to pretend that tears belonged to the weather. He wore no tie. She wore the county windbreaker because she had nothing else she wanted on her shoulders yet. They sat with a distance between them that a stranger would have called polite and a daughter would call necessary. I didn't do it to be saved, she said first, because she had practiced the sentence and wanted to get it out clean. I know, he said. He spoke gently, as if volume had a morality. I didn't recuse because I didn't care. I recused because I did, and because the office needs to work even when I stop appearing in it. Did you know about the camera? She asked. I knew when the paper told me, he said. Before that, I knew what the office knew from the filings, which turned out to be less than what the city knew, which turned out to be less than what one man with a badge decided to do at 6 in the morning. She believed him, then she didn't. Then she believed him again. The belief and the doubt passed like clouds. You could have called earlier, she said, before all this. I could have, he said. I didn't know which call would be to help you and which would be to help myself. I didn't trust my own motives enough to test them on your life. I wrote you, she said. I know, he said. I carried the letter around like evidence I wasn't sure I had the right to open. That's not a proud sentence. He tried to smile and let it fail. I'm not asking for a role I haven't earned. I'm asking for the ability to be asked. Sometimes you don't get to be the hero of my story, she said softly. But you can be in it, if you can stand not being the hero. He nodded. In another life, it might have sounded like a political lesson. Here it was grammar. They sat for a while and watched the river pretend to be permanent. A boy on a scooter scraped his knee and did not cry. A dog decided the water was an ally and charged it happily. The world's refusal to stop helped. The audit began with an interim report that said little and ended with a public roadmap that said enough. Mandatory NTP synchronization for all evidentiary recording devices. Treatment of DVR, overlays as approximate unless validated, immediate. Logged holds on municipal footage with tracking accessible to both prosecution and defense. A discovery portal managed by a neutral clerk's office rather than by police intermediaries. Codified eyewitness procedures with confident statements. Recorded in the witness's own words. A standing conflict protocol for when a case touches the life of someone in high office. The Attorney General announced he would not seek re-election. He didn't add that he was stepping down. That news came a week later, tucked between a voided contract and a grant award, because sometimes dignity is a matter of scale. A nonprofit no one had heard of 2 months earlier landed on the evening news, a small fund aimed at independent technical audits for defendants whose cases hinged on cheap clocks. The first check did not have a name on it. The second did. The police department held a press conference with flags and apologies. The chief said words that had been rehearsed in front of mirrors about new training and discipline. The sergeant who had signed the affidavit retired early and moved 2 counties over. The detective who had written the off-channel line on the municipal email hired counsel and learned to answer questions with the sentence, "On advice of counsel, I decline." A columnist wrote that the only time institutions tell the truth is when telling it costs them less than lying in the long run. The The column was shared a lot and agreed with by people who would have said the opposite if the uniforms had been different. The corner store on First and Alvarado reopened with new owners. They kept the old freezer and put in better cameras. Someone taped a handwritten sign behind the counter that said, "Time is real," in black marker, and laughed when customers asked if it was a joke. The joke was the weapon they had. Amara asked for her student ID to be reactivated under a policy the community college had invented after other students had come back from other machines. The registrar cried at the window and apologized for crying. Amara forgave her and meant it. She enrolled in a class called Evidence, not because she wanted to be a lawyer, she didn't know what she wanted to be, but because she wanted to know the names of the things that had wound around her life like wire. She and her mother went to a thrift store and bought 2 blouses and a black jacket that fit. They ate ice cream on a bus bench and watched a bus arrive, then leave, then arrive again. The driver, who had remembered the coat, pulled up on his brake and said, "Hey," and handed her a transfer ticket with a little smile drawn in the corner because kindness is an art form anyone can be bad at and still attempt. A month later, she met the special counsel for coffee and asked what happened to the car with the partial plate. He told her, in the measured way you tell the truth when there are still proceedings you can't puncture, that the plate was tracked to a vehicle associated with an individual who had been a confidential source in an unrelated narcotics matter, that the individual was under investigation for involvement in a series of robberies that matched the pattern of the clerk's killing, that evidence was being evaluated by a grand jury, and that her name was not in those papers. He did not tell her if charges would ever be brought because even the law lacks prophecy. He did tell her plainly that what had been done to her, by omission and by inertia, was wrong. She nodded, and for the first time since the day of the sentence that had been vacated, she allowed herself the thought that her future might be larger than the shape cut into it by other people's clocks. On a Sunday, she and her father sat in a church she had avoided since the trial, because sitting still made her body remember things she didn't want it to. The pastor preached about the difference between justice and vengeance, and the congregation made the noises congregations make when they agree in principle and are terrified in practice. After the service, he asked if she wanted to meet someone. In a back room that smelled like coffee and floor wax, the pastor's wife produced a stack of envelopes addressed to people waiting on the other end of a verdict. She asked if Amara would speak with a girl whose brother was sitting in county on a case no reporter would write a paragraph about. "Just tell her it's survivable," the wife said. "Or tell her it isn't, but that mornings keep arriving anyway." Amara read the name on the envelope and agreed to call. "I can tell her it's both," she said, "and that neither condition cancels the other." When she and her father walked out into the flat sun, she told him she was keeping her last name as she had it, not because his had become a source of shame, but because hers had learned to stand. He said, "Good," as if relief could sometimes be agreement. At the car, he asked if she wanted a ride to the bus stop, then laughed at himself and said, "That's not how that sentence should go." He walked with her instead and waited with her until the bus arrived. They didn't hug because there are rituals for beginning again, and some of them require practice. The bus pulled up, doors sighing open. She climbed aboard and flashed a card that worked. The driver nodded, that small, sovereign acknowledgement. She took a seat by the window. As the bus groaned into traffic, she watched the city move like a machine made of human choices. There were errors and patches, clocks set to different references, systems that failed and were repaired by hands that shook. The grid was still there, visible in the pattern of streets and laws, but so were the spaces between the lines, room enough for a person to step outside the graph and keep walking. Somewhere downtown, a clerk updated an entry in a database so thoroughly boring it could carry truth without dropping it. Case dismissed, conviction vacated, defendant released. A server synced to an external time source and drifted back into line. The municipal camera recorded a new night and labeled it with a number that matched the clock above the judge's bench. The sign behind the corner store counter still said, "Time is real," and on some afternoons customers read it and nodded like they understood the joke and let the day go on.